So, Ken, lay out for us what we expect to happen today.
Good morning, Anna. Well, this is a scheduling hearing, and the two sides are going to present their proposals for how to move forward in this case. And to answer the question you raised in the opening, there is no chance this case can go to trial before the November election, because whatever Judge Chutkan decides in terms of what she views in bounds, what are official acts and what were presidential acts, that can be appealed pre-trial all the way to the Supreme Court. So there's no way that process plays out before the election. But in terms of scheduling, it's important because it may dictate how much of the evidence, how many hearings we'll have on the evidence in this case before the election, and even after the election if Mr. Trump wins, because the Justice Department will continue with this prosecution until the moment he takes office if he wins. And the first dispute is about what issues come before the judge first. Donald Trump's lawyers want the judge to take up the question of, was Jack Smith appointed illegally, as Judge Eileen Cannon ruled down in Florida? Remember, she dismissed that separate classified documents case on the grounds that the special counsel appointment was illegal and unconstitutional. And so Donald Trump's lawyers want Judge Chutkan here to hear that issue and decide on it. That seems like a remote possibility because the law in this circuit clearly suggests that Judge Cannon's decision was wrong. And it's not just district judges that have ruled that way. The appeals court has ruled that way also. So what Jack Smith wants Judge Chutkan to do is immediately go to the issue of what are presidential acts and whether this new superseding indictment that Jack Smith filed, whether that can pass muster, because he's purged it of what he views are official acts under the Supreme Court ruling. But of course, Donald Trump's lawyers disagree, and they're going to argue that a lot of the conduct he's still alleging in this case should be out of bounds. And so that's the main dispute. Today's really about scheduling. The lawyers are in the courtroom. Donald Trump is not here. The lawyers will, though, enter a plea of not guilty to this new superseding indictment, which, again, contains no new allegations. It merely narrows it down. And so we'll see what happens. It's going to be an interesting day.
Okay, thank you, Ken. Stay with me. We do have an update from the courtroom. Chutkan is on the bench. Court is in session, and because it's federal court, no cameras in the courtroom, but we are continuing to report out what happens there. So Christy, Judge Chutkan had quite a bit of a waiting period here as she waited for the Supreme Court to make this decision on presidential immunity. How do you see this case moving forward, and what will you be watching for specifically today?
So I think Judge Chutkan is going to have no time for any of the delay tactics that Trump is proposing in this report. As Ken said, he doesn't even want to get to immunity. Before it was immunity, I have immunity, I have immunity. Now I don't even want to brief that. I want to talk about why the special counsel shouldn't be here, which the Supreme Court has said in its opinion, you got to deal with these immunity issues at the outset of the litigation. They were pretty clear about that. So Judge Chutkan is going to look to get back to business right away. And I think she's also going to be skeptical because Judge Trump could have made that argument about the special counsel way back when he was making the immunity arguments. And he didn't, because as Ken said, the law in the circuit is so clear that there's no argument there. I also think she's going to be very skeptical of his arguments regarding the immunity litigation. He's saying we can't get to briefing for months because I need all this discovery. Look for Jack Smith to say, you have it. Let's get started. Let's get to the briefing. I think she will absolutely be no nonsense. Look to get this on track quickly.
Barb, there was this superseding indictment after the immunity decision. How strong is this case after the Supreme Court's decision?
Oh, it's plenty strong, Anna. You know, I think that the main allegation that has been removed was Trump's alleged efforts to abuse the Justice Department as part of this whole plot. Personally, as a former DOJ employee, I found that among the most egregious of the charges. But it doesn't really diminish what's left, which is pressuring state legislators, fake slates of electors, and exploiting the chaos at the Capitol to pressure members of Congress to continue to block certification. All of that remains in the case. I also think it's noteworthy that some of the language was changed to reflect a different Supreme Court case, another case called Fisher, where the Supreme Court said to obstruct an official proceeding, it must involve documents. And so this new superseding indictment points out that it's all about the documents. It's about the slates of electors, the ballots that are kept in the big mahogany box that was carefully safeguarded by staffers during the chaos at the Capitol. So the case remains strong, and I think Jack Smith is itching to go.
I'm just looking at what's happening right now inside the courtroom, and Chutkan did actually start out making a joke with Donald Trump's lawyers, noting that he looked rested. It had been almost a year since they had seen each other, and so she said, "You look rested," and as he introduced himself and joked, telling him to kind of enjoy it while it lasts. Ken, you talked about how because of the delay and sort of the backlog of decisions that have to happen before this can go to trial, where does this case go next?
Well, it depends on what Judge Chutkan rules today. If, as we all believe, she's interested in expediting and getting things moving, presumably there could be a hearing or a series of hearings examining this question of what evidence should be in bounds here, what are official acts and what aren't official acts. And that's consequential because that may require a lot of evidence to be put in front of the American public that those who haven't read the indictment aren't familiar with. In the middle of an election campaign, we're going to hear more about how Donald Trump tried to stay in power by allegedly conspiring to violate the law, to deprive millions of Americans of their right to vote, to obstruct Congress. So that could be a big deal. It could all transpire in this courthouse behind us before November.
Christy, the Trump legal team's strategy has been delay, 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 but Judge Chutkan did tell Trump's lawyers last October to sort of set the tone for how she wants to approach this. This trial will not yield to the election cycle. Already today, she's saying she won't make a ruling on the schedule, but she is also saying she hopes to get an order out later today. So that also indicates she wants to move swiftly. Realistically, how quickly could this move?
So I think first and foremost, you're going to see briefing, right? That is what the special counsel has requested. They said, we're ready to go, Judge Chutkan. Anytime you tell us to, we will file this brief explaining our indictment, why it's justified, why the Supreme Court's opinion does not affect any of the acts that we've alleged here in this indictment as criminal. And so I think she'll set a quick schedule for that briefing to occur. And then the real question will be whether or not, as Ken said, those hearings happen before the election. I think the briefing will take some time. It's going to be pretty fact intensive. And so, I think given that there's been some delay in getting to this conference, initially it was supposed to be in August and now we're in September, I'm a bit skeptical we'll get those hearings before the election, but the briefing is going to be substantial. There is going to be a lot of facts laid out there. And so even if we don't get to those hearings before the election, I do think there's going to be a lot for the American people to learn from Jack Smith's briefing.
And they have this new superseding indictment that's come between that decision and today's hearing, and they're going to be talking about that. She did just accept the not guilty plea entered on behalf of Donald Trump's team. Barbara, the Times had pointed out that soon after the indictment was returned to Judge Chutkan following the Supreme Court ruling, she told Trump that when he was in her courtroom, she planned to look on him as a criminal defendant, not as a former president. As for the fact that he was running for office again, that, she said, somewhat dismissively, was his day job. What do you take from that?
Yeah, I think that really sends a very important message that no one is above the law. You can't get out of a criminal trial simply because you're running for president. Otherwise, anyone would simply announce their candidacy and thereby be able to divert their criminal charges. But I do think it means she's going to push forward. We are going to see those briefs. Some have suggested that there might be a mini trial where we hear live testimony. I'd be surprised if that's the case. I don't think either party wants that. It's not a terribly efficient way to proceed. But I do think we are going to get briefs that spell out in detail the allegations and the evidence. The other thing Donald Trump has requested because of his candidacy is that these briefs be filed under seals so that the American people do not see these damaging allegations and evidence. But I think going back to those words of Judge Chutkan, she is unlikely to grant that because there is a presumption that documents that are filed in court are to be unsealed and in the public domain. And so if she's to treat Donald Trump like every other defendant, then I think we will see these briefs in their full glory.
Ken, we're just about 10 minutes into this hearing. Seems to be moving pretty quickly.
Judge Chutkan for you. She does not fool around. She is the exact opposite of Judge Eileen Cannon, who ponders and mulls and questions every move by the lawyers and every brief before her. Judge Chutkan keeps things moving in her courtroom. And so we could be done with this hearing before we thought.
And Christy, assuming no trial before the election, just remind us, what happens to this case if Trump is elected? And what happens if he isn't elected?
If Trump is elected, this case goes away. He will direct his Department of Justice to dismiss the charges against him. So if he's elected, we're done here. And that is the same with the Florida case. He will direct his Department of Justice to drop any appeal there. If Kamala Harris is elected, this case will continue. She presumably will have her Department of Justice continue with this case. There's a new attorney general. Presumably that attorney general will understand and appreciate the importance of both of these cases and stay the course.